Mr. Mumford, you're charged with terroristic threat. You're facing up.
It's a $2,000 fine and 6 months in jail. Scare tactics aren't the only reason behind those statistics. That is the actual maximum penalty for this offense. And as soon as probable causation is discussed, the clock begins to run.
6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On October 4th, 2024, officers were dispatched to a call at a parking garage in Harris County, Texas. Officers made contact with a complaining witness who stated that she and her coworkers, including the defendant, were working at the parking garage. And the complainant messaged the defendant asking where he was located. And the defendant suddenly arrived at the third level where she was located and began to yell and scream at her. The complainant stated he threatened to beat her ass.
Take note of how certain threats alter the game. It's not ambiguous to beat or bleep. Straightforward and combative, which in legalese is evidence of purpose to incite terror.
Were they together at the same place?
They were on the same, so they both work at the parking garage, I believe, and they were both on the same level. Like it was in person with everything.
Did you say she was in fear?
I don't see that alleged in the OR.
Mumford.
The only thing the state would say that our position is, I know it doesn't say that complainant said she was in fear for her life and the charging instrument. It's not one of the elements we have to prove.
And 5. The important thing to remember is that Texas law does not need them to demonstrate that she truly feared for her life. They just need evidence that he meant to instill terror in her. The secret to this statute is intent.
We just have to prove that the defendant intended to place the complainant in fear of serious.
I don't know. Let's see. A person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to place any person in fear of imminent serious bodily injury.
So, and Judge, just to remedy the issue, we checked the probable cause affidavit on the charging instrument. On the PC affidavit, it does say that she stated she was in fear for her life.
That's the only thing I want to know is she in fear? How do we know?
Yes, Judge.
Because a lot of people make these stupid ass threats all the time, and it's just, tell me what it says. And does she say that she was in fear?
Let's see. Well, it does say that the defendant came to level 3 where she was located. He began to yell and scream at her, threatened to beat her ass. She stated that this scared her and made her in fear of serious imminent bodily injury.
And where is that?
This is in the charging instrument, the PC paragraph.
That's just the charge. But I get it. That's just because they put that in the charge. Nowhere in the OR does it say that she's in fear. Nowhere else does it say she's in fear. That's just because they always put that on every information with regard to this.
I understand.
Yeah.
The only position we have is that it's not one of the elements the state has to prove.
I don't agree.
It's quite unexpected. Look, the court says the evidence does not sufficiently demonstrate fear. The case was dismissed. But a warning was given that words have the same legal weight as a loaded firearm.
I'm going to find no probable cause in your case. The only thing I'm going to tell you is be careful, really. Words have meaning. Words can hurt, right? Pen is mightier than the sword. Words can hurt. Just be careful, all right? Okay, take a seat, please. All right, come on up, sir.
Stand here. Please, please. Okay. And Judge,
The raising end.
Raising.
Good
morning, Judge.
Good morning, sir. So you're charged with interference with the duties of a public servant, and this is a Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. We're going to do probable cause. Just hang tight, please.
Officers were dispatched to a disturbance between the defendant and an Uber driver in Harris County, Texas. The officer stated that when he arrived, both parties were calm and smoking with one another.
This begins modestly. Notice how intoxication in a public place swiftly escalated this from a ride-sharing complaint to a police issue, despite two persons arguing about charges.
Officer stated that he saw that the defendant was intoxicated and asked whether the defendant's wife would come and get him. The defendant said his wife would. And the defendant and the Uber driver began going back and forth with each other about charges. An officer made the decision to detain the defendant and take him to a sobering center. Officer asked the defendant to put his hands behind his back, and defendant tensed his arms. Additional officers arrived and detained Pete.
Judge, I know it's not, you don't argue.
Tensed his arms? Really?
Judge, I know it's not time to argue problem, but I like
No.
shit out a little bit.
I already got it.
Yeah, Judge.
I understand. What kind of, just you're tensing your arms? That's madness.
This is known as resisting light in courtroom shorthand. You're not attacking police officers? Even stiffening up, however, can be twisted into meddling with a public official. A small action with a significant legal impact.
We have enough cases. Come on. No, I'm going to find no probable cause. Just remember, when you're out there in the free world, if you're going to get lit, be very careful. Do you understand, Mr. Thurston?
Absolutely.
I'm sorry, did you want to say something?
Oh, it's okay, Judge. We're dismissing the case.
Oh,
Just be careful, really. Okay, all right, we got you.
Two very different defendants, two different endings, and one obvious lesson. Your body language and words can be just as significant as the actual facts.
Thank you, Judge.
Thank you, Mr. Penn.